It's Kilby Browne with the Property Hats New York City Team, and we're going to welcome today Hal Coopersmith. How are you, Hal?
Great to be here. Sorry, I don't have a hat to match yours.
I don't know if you can see it, but I got plenty of hats here. I should have shipped you one for the event, but
That's right.
all right.
Bow tie.
Or the bow tie. Don't worry about it, Hal. Don't worry about it. So you are a New York City real estate attorney, or how do you describe yourself?
That's a perfect description. I'm a New York City real estate attorney, and right now I'm very passionate about talking about residential rentals because I've also developed some software to help residential landlords comply with the sweeping rent reforms that went into effect last year.
Okay, so I think that's as good a place to start as any. We can go back to last June or go back to wherever you think the right point is to start this story. What did happen in the reform of the rent laws last summer?
It's a good question. So last June, New York State enacted the Housing Stability and Tenant Protection Act, which affects residential rentals, not just in New York City, but across all of New York State. And a lot of what happened in the law got a lot of attention. For example, a security deposit is limited to 1 month's rent. A late fee is capped at $50, and you can no longer collect more than 1 month's rent in advance. So you can't collect first and last month's rent, or if you were even so lucky to get a tenant to pay a full year in advance, you can't do that anymore. But there's a lot more requirements in the law that people aren't necessarily talking about. So if you're a landlord and you're renting out your apartment, you have to send out a notice either 30, 60, or 90 days, depending on how long the tenant has been in the premises, whether you're going to increase the rent by more than 5% or the lease is going to expire. You also have to offer the tenant a walkthrough within a 1-week window of time, and that window is 2 weeks before the end of the term and 1 week before the end of the term. And you also have to return the security deposit within 2 weeks. So our ResQ software informs landlords and brokers, trusted advisors like you or managing agents, about all these requirements as they kind of come up. And we send email and text message alerts or queues as part of our ResQ software that save or rescue landlords and brokers from lease noncompliance.
Makes sense. Makes sense. So if let's just take a quick break and take a look at this from the tenant point of view.
Mm-hmm.
So I speak to a lot of tenants, and they say to me, okay, Kilby, I don't really understand why this law was changed. I have money to pay 6 months or a year up front. I can't get the apartment I want. Why did they change the law? I might not have the income to qualify for this apartment, but I know I have the money in the bank. If this was a year or two ago, I could have gotten this apartment. Why did they change this on me?
It's a very good question, Kilby, and I think that the perspective of the New York State Legislature is to make the law more tenant friendly. And for example, that's capping the late fees at $50 regardless of the rent that a tenant pays. So for a $2,000 a month rental up to a $25,000 a month rental, $30,000 beyond, that late fee is still capped at $50. Same, for the walkthrough before the end of the term. It's really to give the tenant an opportunity to fix any damage that may be imposed, and maybe there were some landlords, maybe in New York City, that were kind of dinging tenants unnecessarily on the security deposit. So that's and around New York State. So maybe that was the case. Maybe exactly. But in your example, in terms of paying, more than 1 month's rent in advance, tenants certainly may want to do that. And there are, like any law, unintended consequences. And so this is one of those unintended consequences from the law. At the same time, from a tenant's perspective, they may say, you know what, our landlord was charging or trying to get first and last month's rent, and then maybe additional month's rent, and for an average tenant out there, that's a big upfront cost. So the perspective of the legislature is really to prevent against that. And sometimes not the whole baby's thrown out with the bathwater, but that's an example of that situation.
Yeah, part of it's going out with the bathwater. I mean, I'm seeing that a lot with international, especially international students. You know, maybe it's a Chinese student or student from Latin America or Europe. They come here, they go to NYU, for example, and they say, okay, where do I send the check for the year? Because obviously they can't show income or prove income here in the United States. And they say, wait a minute, what happened? I could do this last year, I did this year before, my friends all did this. You know, what happened in New York City?
Right. Yeah, and that's a very difficult situation, and there isn't really a great solution for that out there that is legal. I mean, you can, and particularly for foreigners in terms of domesticating the funds, that's certainly an issue as well. There are potential workarounds, but rather than go into depth about that, you know, we could just talk about how that's a situation where the law has really prevented something from happening.
Exactly, exactly. Joy, can you touch briefly on, because a lot of the tenants I talk to, they start to grasp some idea, and then they get hit. You know, they say pet deposits or condos charge these fees, co-ops charge these fees, and they get very confused over who can and who can't, and what this law covers and what this law doesn't cover.
Right.
Charge the processing fees, dog fees, etc.
Yeah, it's a very good question, and it's not just tenants overall. It's a lot of the marketplace. So part of the law is that an application fee that a landlord may charge is limited to $20 for a credit check. And in New York City, obviously, there are co-ops and condos and larger buildings where there are additional fees charged. Right now, those are legal. And if you're a broker collecting those fees, there's a safe harbor for collecting those fees on behalf of a building. So brokers are still able to do that. In addition, in terms of additional fees for the tenants may pay, the brokerage commission is a big one. And talking about that $20 application fee, the cap for that, interpretation from the New York State Department of State was that tenants no longer are able to pay a brokerage commission as part of that. That was challenged by REBNY and other parties. That's due back. Other parties that's due back in court in September. So right now, tenants can, as we're recording this at the end of June, tenants still can pay a brokerage commission. Otherwise, it would be payable by the landlord.
Exactly. I was lucky enough to be at one of the June hearings, or I guess the only June hearing. That was an interesting day to see how the city council was trying to figure this whole thing out. A lot of the panels, a lot of the testimony on both the landlord, tenant, political action groups, whatever, were making their points well known. In addition to the little change that came out, I guess it might have been beginning of February when they kind of readjusted what they said the $20 was, or that fee was. And then that was a big brouhaha. Obviously, maybe it will be settled in September. And we'll have a final either way in that one.
That's right, and there's a lot of confusion about the law to start. And in addition, and if you're confused about the law, that means you're aware of the law. But aside from that, what I've found is that there's not a lot of awareness of the law, particularly on the landlord side. And I think that as the market gets more information, landlords who aren't prepared now, rest assured your tenants will wise up by the time that lease renewal comes up. And if you're a landlord and looking to sell your building or find a new tenant and you haven't sent that lease expiration notice, or you've done a concession right now in 2020 and the market back, rest assured your tenant will be on top of their game, and they have the right to continue the lease on the same terms and conditions, or demand that the rent not be increased by more than 5%. And if you're a landlord in either of those situations, you're either losing money or leaving money on the table.
Exactly. And some landlords, they might not live in New York, they might live in a different state, they might not be reading the papers, they're relying on, if they don't have a full-time exclusive agent working on their behalf, they just have, random agents in and out renting apartments in their buildings, so no one is really passing along the information to them. And if they're not picking up the paper every day or online every day, and a lot of them are not, into the online world of some, younger people, then they're out and they're not, this whole story is kind of going either over their head or around them, or they're just not aware of it.
Exactly. And so that's why I'm trying to get the word out and talk about the compliance aspect that landlords have to do, and you really have to be more of an active participant in your property, or hire someone or have an advisor who is aware of the law.
And are you seeing any difference? I mean, you would think that the bigger buildings with multiple buildings, larger corporations, would be a little more up on this than some of the smaller families or some of the individual building ownership. But I know even when this law changed back in June, even some of the companies that own many, many buildings, they should have known about this right away, but they still resisted in a lot of different aspects. And individual deals I tried to do even.
Yeah, so I think some, the market's still kind of percolating through. Some of the larger landlords I've seen, just from anecdotal evidence, are sending out these non-renewal notice or rent increase notices on time, and have probably incorporated a procedure for walkthroughs as well. But there's not a lot of information on the market right out there, and particularly for smaller building owners. Individuals, just like you said. And so that's why we developed this ResQ software to assist with smaller landlords, individuals, people that don't necessarily have sophisticated property management software for hundreds of units.
So how is that set up? Is that like a dashboard, or is that an email alert system, or how does the whole, is it a software? How does the system work?
Right. So it's a good question. So our system, as I mentioned, you have to send the non-renewal or rent increase notice 30, 60, or 90 days before the end of the lease term. So ResQ, our intelligent lease management and compliance software, sends out the first series of alerts 45, 30, and 15 days before that deadline. That deadline is calculated based on how long the tenant has been in the premises. So if you're an individual owner, you get an email and a text alert that making sure that you check your phone, get buried in your email inbox, and then can also send it if you're outside New York City, or have a trusted advisor or managing agent who's kind of assisting you with the property, your eyes on the ground, someone who says, you know what, rents have improved in 2021 as opposed to 2020. We want to increase it by more than 5%. You have 45 days to get your heads together and figure out what you want to do with the property. And if you don't do that on the first 45-day alert, that's why we send the next one 30 days before the deadline. So you still have an extra month to do that. And then if you still haven't done that, you have a 15-day alert, just the third time's a charm. So that's the first series of deadline. If you are not renewing the tenant, and then if you're renewing the tenant, let me start there. We deactivate the alerts and then set it up to go back to queue back in for when the renewal date expires. Second sequence of alerts to make sure that the landlord knows about the walkthrough and return the security deposit within 2 weeks. And that's important. So make sure that the landlord won't be paying for repairs out of their own pocket instead of out of the security deposit. And if you think about the beginning of our conversation and the intentions of the legislature to protect tenants, the walkthrough is important because you don't want those unscrupulous landlords dinging tenants for unnecessary repairs. And if a tenant does challenge repairs, the court's going to ask, hey, did you do this walkthrough as this law requires? And if you say, well, I didn't know about that, that's not going to fly in court.
So how does a landlord get a hold of this ResQ, or how are they introduced to ResQ, or how does it work for them, not, as opposed to cost or stuff like that?
Yeah, it's a good question. For all leases that we prepare, it's included in our leases. And if you want to learn more about it, you can go to resqme.com. And for Kilby, your viewers and listeners, we're happy to offer a beta test at a discounted price. And so if you email us and go to resqme.com and just in the subject say Property Hats, you'll get a discounted rate. And so we're happy to offer that to your viewers and listeners. I won't say the price, but I will say it's extremely favorable as to what the market will be.
And it's, without even asking what the price is, I guess the price compared to getting a fine for not returning the money, and there's a certain date or any of these things that happen to them, they don't want to end up in court. They don't want to get fined. That's time. That's money. That's a whole other hassle that landlords don't want to deal with.
Right, and think about just increasing the rent by more than 5% and being on top of your game, getting a few extra percentage points just as you're discounting property right now, and in terms of not having to pay for a repair out of your pocket, and then just overall having something where you've paid a one-time fee that I should say is very approachable for a large for our market once we do go more live with it. That it is extremely favorable to just not have to worry about it and not have to call up a lawyer like me and say, well, what do I need to do now? Make sure that all the time spent not having to calendar all those reminders. I think it's a very valuable resource.
So you write your own leases?
For some clients do retain us to write leases. We have a lease that mirrors the REBNY form with a rider, so it is again something that's very approachable for a tenant. Market standard. I feel very comfortable in a rider that it's not one paragraph and it's not 40 paragraphs, but it's the right amount of protections. And for clients that do retain us, what we've been able to do for the landlord and the broker, we have a digital intake for that mirrors the REBNY form, asks all the questions that you may have thought of, some which you may not have. For example, what happens if an appliance breaks during the term? How much insurance should a tenant require? So we have that all digitally online. Then we're able to generate a lease very quickly and make it very approachable for landlords and tenants alike.
What advice do you have? I've spoken to landlords. I've just seen this in my course of practice, where a landlord says, okay, they're now they're getting used to the new REBNY lease, and they say, okay, I want to strike this clause, I want to strike that clause, and I want to strike that clause, and then I sign it, the tenant signs it, and then they just think they have a lease that's good to go. You're a lawyer. What's your opinion of that?
Well, in order to have a valid contract, you need two signatures. And so the best advice for a tenant overall is, if you're not happy with some provisions in the standard form of lease, and I'll tell you that there are some provisions that you rightfully may be unhappy with, to approach the landlord overall and say, these are the things that I don't think are justifiable or that I don't want to do. And it's much better to do that from the outset, as opposed to striking it out and seeing maybe I can pull a fast one off the landlord.
Yeah.
Particularly within real estate, you're establishing a relationship, and with leases overall, as good as any lease or any contract is, you're never going to anticipate all situations. So if you're starting off on the wrong foot just by trying to get a fast one by, or just trying to speed things along and not necessarily thinking about it, that's not a great way. When something breaks down and you need to get a repair done, the air conditioner breaks down when it's 100 degrees, or it may not be super incentivized to get someone in there the next day.
That makes sense. And in these days of COVID, and obviously there's a lot of stuff going on in the market, people are either losing their job. They might be getting a pay cut, the tenants. And let's say they signed a lease 6, 7, 8 months ago. Do you have any advice on, I'm getting these calls all the time. Kilby, what can I do? I signed the lease. Place is too expensive for me. That's it. What can I do? What are my options?
It's a very difficult situation, and certainly empathetic to a lot of tenants who are in that situation. And in New York City, we have a lot of big landlords. We also have a lot of individual landlords who aren't the big bad wolf that landlords are depicted as. So it's balancing those situations. If you are facing financial hardship, these are a couple things that a tenant should know. First of all, a late fee, as we discussed earlier, is capped at $50. So if you're not paying your rent, there can't be a substantial late fee regardless of what your lease says. That's capped at $50. There's a moratorium on that late fee through August 20th. Depending on how much time you have on your lease, the best thing to do, knowing about the late fee cap and the moratorium, as well as everything that's going on in the market, is to try to strike a deal with your landlord. Understand the situation. Say to your as we're recording this at the end of June, look, the moratorium is through the end of August. We don't know what's going to happen after that. I'm in a difficult situation. I can show you what's going on. Could you let me out of my lease if I pay X amount of months? And then, and first and foremost, and then in addition to that, you may want to say, I could pay you X amount of months, but how about I pay that over time as well? And that's an advice that we've been giving to tenants as well. It's a difficult situation. And like I said, there are smaller landlords out there. You do have a valid contract. The landlord can enforce that contract. I'm sure that, come the end of August, September, or who knows when the eviction moratorium may end, that we'll see a lot of cases coming to court, and that there is a lot going on there. But landlords say at the end of the day, I have a valid contract. I can hold on. I certainly will. And then they're relying on people like you to try to re-rent out those apartments and figuring out what that new market looks like.
Can you touch on, a lot of people ask, I think I read that I can use my security deposit as one of my month's rent, but if they do use the security deposit and but maybe toward the end of the term and the landlord says there's an issue with some damage, how does that get resolved?
Right. So Governor Cuomo in New York said that with an agreement with the landlord, you can use the security deposit towards a month's rent and agree to pay some of that back over time. And I think that if first of all, if you are a tenant and you apply to rent and then you are either replenishing the security deposit or you haven't had the ability to replenish the security deposit and there is damage, first and foremost, it kind of goes back to our original part of the conversation. Have that walkthrough with the landlord in that 1 week window. Go through what damage there may be. If you're a tenant, document the condition when you move out. Take photos. Make sure that there is that you are showing no damage. And then at the end, if there is damage and the landlord can document that and show that to you within the 2 week period as required by the law, you want to make sure that you kind of you're liable for that. So you want to figure out a way to make the landlord whole, because again, that is part of the agreement. As much as we have empathy for tenants, we can also have empathy for landlords as well.
Exactly.
And you can't leave your place a mess. Can't if you put up a TV, can't leave that gaping hole in the wall. And so it's important to leave the premises in the condition that you receive them, and the legal term is less reasonable wear and tear.
Makes sense. So people ask me about Very good question. I lost my train. I lost my train of thought for a second. Um, my gosh, what was I going to ask you?
People ask you about your hat. We can
People
talk about
ask me
that.
about my hats, and they ask me about where I buy my hats and why I wear a hat, and that's okay. And people definitely do ask about that kind of stuff. So, wow.
I was trying to buy you a little bit of time there, Kilby.
Yeah, you kind of trying to buy me time here, but
Now we're going to ramp a little bit.
I just completely spaced on my question. Now I'm so focused on that question, I gotta take a step back and move on to the and just find another one. That's okay. So in terms of COVID, does the tenant have any? What rights does a tenant have to say, I don't feel comfortable having someone come into my home right now during COVID? And what rights does the landlord have saying, well, it's 30 days to go before you're out and a new tenant is coming in and I have to show the apartment? That was my question.
It's a very good question, and there's ambiguity in the market, and there's certainly various situations overall. Let's say you're an elderly tenant, you're immunocompromised, and you're able to document that. You certainly have good reason not to allow people in your apartment. That actually happened with me early on in COVID with a landlord who's immunocompromised, and trying to figure out how to execute on that walkthrough, which we talked about. And so, what I can say overall, phases are changing. What's allowed under executive orders are changing. I don't want to make a blanket statement for all situations. You do have a lease agreement which does permit walkthroughs, but there may be very good reasons why a tenant is able to not permit a walkthrough with good reason to do that. Permit showings. We've had virtual showings overall. And maybe if you're a landlord and you're in one of those situations, you want to figure out a solution that works for both you and the tenant. So maybe trying to figure out a day where you can batch a lot of showings overall, and arrange for a cleaning crew to come. And that would be a reasonable accommodation for the tenant overall, while making sure that you're able to, as a landlord, rent the space, and preserve your rights under your lease, which are important because you are trying to do that. And it's really about the landlord and tenant coming together. Hopefully, in these times, that's a very important thing just for all of us, and all of us as New Yorkers. And that's kind of what we have to hope for in a lot of different ways, not just the residential lease.
Exactly. Wear a mask, be cooperative, negotiate, try to keep it even keel, have a dialogue, do all the things to have some back and forth where you can come to a reasonable conclusion, a reasonable agreement between the two parties, as opposed to being very combative and being very, this is my final answer, and have a nice working relationship amongst all the people in New York, which.
Yeah, and that goes back to the start of the lease and not crossing off a lease, some of those clauses, and trying to pull a fast one, or trying to be, just generally, particularly during this time, very respectful and have a rapport, if you're the landlord, with the tenant to the extent you can with your landlord, and just, it's situations like these that can't necessarily be predicted by a lease, because no one saw this coming when they were writing leases around this time last year. So even though you can see it now, it's just trying to come to a nice solution between landlord and tenant.
Thank you. Does a tenant, I've spoken to some tenants who say, Kilby, they closed our amenity space, they closed the gym, they closed the lounge, they did this, they did that. My rent's the same. Does the tenant have any recourse as to, does the tenant have any recourse to that?
Yeah, it's a good question. First of all, it depends on what your lease says. Some leases may very well say This is your rent, regardless of what the amenity space is. And so that's the first and foremost, because at the end of the day, amenity is an amenity. And if you're paying separately for an amenity space or use of amenities, which is possible, and the amenity space is closed, you should absolutely not be paying for that amenity space. But first and foremost, you have to check the terms of the lease. Also it depends overall, to the extent, again, it's about the landlord and tenant coming together. So if you're a landlord and you have a tenant who can't use their amenities, who's someone that maybe you want to keep and kind of come to a short-term solution, it may very well be in your best interest to make an accommodation for that tenant, regardless of what the lease says, and maybe say, you know what, I'll make an accommodation for you now, but in exchange, I'd like to extend the lease overall and kind of have a trade in that regard. So again, to answer your question, it depends on what the lease says, but overall, if you're the landlord, you want to avoid litigation because there is that moratorium, and informed tenants, because they've been watching this, knows that late fees are capped at $50, that there's a moratorium on late fees, and they say, you know what, I have the upper hand for a period of time. I'll try to extract what I can from a landlord.
And also, if a landlord is reasonable and smart, they can also, by being fair, they can also decrease their vacancy because the tenant's not going to move out. Because the tenant gets upset, they're just to move out. And it could take 1 month, 2 months, 3 months, depending on the type of the apartment and what happens going forward. During this summer with COVID, how long does it take to rent that apartment again?
Exactly, and not only that, it could be a lower rent depending on the property, and people may say, I want to avoid New York City for a period of time. I'll move out and get more outdoor space in outside of New York City, and if they're able to execute on their jobs outside the city. There's more space for children outside the city as opposed to a bigger apartment, and so that has to be a consideration as well.
Exactly. I mean, there's been a big, especially on the rental side, there's been such a big push in the last couple of years for more of amenity-driven rental space. So you have smaller apartments, more gyms, more lounges, more yoga rooms, this and that, where some of the older stock, as you well know, the older buildings might have focused on larger apartments and maybe just a doormat. But now you're into the smaller apartments, and the people are like, oh, I need more room. It's great to have, the lounge, but if I can't use the lounge, this happens again. This comes back to New York harder, then I'm stuck back in the same old, studio or one bedroom trying to do Zoom calls, do my work with a kid running around.
Yeah, and particularly because people have been boxed in for a long period of time, they certainly don't want to go back to that same box when the weather gets colder again, and outdoor space like a park or anything else like that is less available. And so that's obviously something, as you hit on, that landlords should take into account, particularly as they're trying to navigate these times.
Do you feel that your rescue me, if I'm saying correctly, is paving a smoother path for either terminating a lease or the move in, move out? Is it kind of making things easier, even easier for the tenant as well, because they're going to be notified, and once your software notifies the landlord can notify, for example, me or the managing agent, and the whole process can be a little smoother and not as last minute, and the tenant will be less upset and maybe feel more inclined to renew their lease because they're not shocked at the last minute with the news.
Yeah, and that exactly right. That's the design of the software. And from my own practice, even with high-priced rentals, a lot of the renewals came in last minute. And the way I described it is, the lawyer's always the last to know. The landlord's not necessarily thinking about it, and the broker isn't getting direction from anyone. And so, or managing agent is not getting direction from anyone, and that's kind of where the ball gets dropped. So the ResQ software does bring the landlord and their trusted advisor on the same page. We also know when the notices go out. So if we're the attorneys working with the landlord or working with the managing agent, we're able to see these alerts, understand what's going on with the property. Are you thinking about selling it? Are you thinking about renewing someone? And so everyone's on the same page. And from a tenant experience, Kilby, you're absolutely right. When you see a landlord who's on top of their game, thinking about things earlier, it gives the tenant more time to think about their next steps and hopefully have enough notice before that rent increase or rent expiration notice goes out. So from a landlord perspective, what you're able to give the tenant enough time to make their decision, and at the same time, you're able to send out your notice either of a proposed rent increase or rent expiration. So first and foremost, if you're increasing the rent, you're not leaving money on the table. And second of all, if it's a lease expiration, that the tenant can't continue on the same terms and conditions until you send out that lease expiration notice. And that empowers the landlord to make the decisions that they want to make, not necessarily be beholden to the tenant because they weren't on top of their game in terms of complying with the law.
Mm-hmm. It's very good. It's very good. Is there any kind of percentage? Do you have any kind of feeling what percentage of the people that you speak to that know everything that's going on with the new law that was passed in June, with some of the I don't want to call them tweaks, but some of the guidelines that were put out in February? It just seems to be, even though it was in the paper, it's every day for a week. Back in February, that was more about, you don't need to pay the broker anymore. It was kind of about that, but very little about what the real law was about when it was designed back in June.
Right.
And that being said, so many more people need to understand the whole realm of this.
Right. So in terms of percentages, what I would say is 100% of the people who I speak to, I try to get them to know the law. So that's why I'm here, and in terms of getting out information into the marketplace. I can't say in terms of the whole marketplace what people know or what they're doing. But to your point, there is a lot of confusion about brokerage and the law and what it means. I think that overall, people know some aspects of the law. There've been different aspects the more people I've spoken to, but as I've been saying, it's important to know all your obligations from the landlord side, and then, like I said earlier, tenants will know the law. Rest assured, when it's time for their lease renewal, and their landlord saying, I want to raise the rent by 10%, and they haven't sent a notice, or we're not renewing your lease because whatever reason, and the tenant will say, what, you didn't let me know, so I'm just going to hang out here for the several months that I'm allowed under the law until you send out that notice. And so right now there may be confusion about the law or not a lot of information about the law, but that information will percolate through that market, especially coming from me, as I've been trying to inform as many people as possible about it.
Exactly. No, you do a very good job of it, and it's very needed. There's just a lot of confusion, and what you're doing is very helpful for landlords. It's very helpful for tenants. It's a good system to have. It's kind of like a check and balance. That way, no one is surprised and things go smoothly.
Yeah.
So, if it's okay by you, I think we might still be on Facebook Live. We'll put this on my podcast. I'll put this on YouTube. I'll put this on all my pages. I'll put this out there. And anyone who has questions, they can come through me, and I can refer them, if it's all right, to you. And they can, if they want to use the software, they can say the Property Hat, something like that, and then you can start a dialogue with them to see if they're if they're a good fit for your software, right?
Absolutely. Again, if you want to learn more about the software, you can go to rezcueme.com, rezcueme.com. you can visit my law firm at coopersmith.com. Just to your point, if you send us an email saying with Property Hats in the subject or the body of the text, we will offer you a very, very special promotion, even though I am not wearing a hat.
Well, Hal, thanks for coming on. Hats off to you. You're a gentleman. This sounds like a really, really good tool, a good piece of software, and it probably is going to end up saving a landlord a lot of money than having to go to court and having problems with their tenants. So this really could be a very, very helpful thing in the rental real estate market in New York City.
Thank you, Kilby. It's been great being here and talking to you about everything that's going on.
Have a great day. Thanks so much.
Thank you.
Bye-bye.